The moderator for today is Jordan Ayton. Most of you know him. He doesn't really need much of an introduction, but I would like to take a few seconds to introduce him. This will give him some time to come to the mic. From 2012 to 2018, Jordy was ranked by Lexpert as one of the top lawyers in the field. He's an adjunct prof at Osgoode Hall, and he's counsel to Hull & Hull. I've had the pleasure to deal with Jordy as adverse counsel on files, as a mediator, and I'm not embarrassed to say, as a mentor. He combines a keen understanding of the law with flexibility when needed and resolve where appropriate. I appreciate his participation, his long-standing participation as one of the committee members of the B'nai B'rith Estates and Trust Group, and his agreeing to be our moderator today. Jordy?
Good morning, everybody. I have the pleasure of introducing our first three participants in the vignette, the number one vignette. And the first is Brad Phillips, a lawyer with Wagner Sidlofsky. He's an experienced litigation lawyer concentrating on commercial, estates, and insurance litigation. He's been lead counsel at trials and appeals throughout the Ontario courts. We also have Greg Sidlofsky, certified by the Law Society as a specialist in civil litigation. He's appeared before all levels of courts, including the Supreme Court of Canada. And lastly, Peter Weissman. Peter is a fellow of the Chartered Professional Accountants, and he won the STEP Founders Award for Outstanding Achievement. He is also the recipient of the Michael Kadesky Volunteer of the Year Award from STEP. So I welcome the three gentlemen to the panel, please.
All right, well, thank you, Peter, for joining us. As you know, the claim has been issued and served. So this meeting is to discuss our next steps going forward and some specific key issues that we're going to be facing in the litigation.
Greg, I'm sorry to interrupt you, but I had to do this. My kids, Brad, they're huge fans.
I figured as
They
much.
grew up with you.
Makes sense.
So please, I brought a picture. Can you autograph it? I promise it's for my kids. Can you just say to Peter? So,
Sure,
right.
yeah.
I represent them. So
Should I put-
to Peter is
Okay,
perfect.
to Peter, and a heart?
Yeah, they love hearts.
Okay,
Yeah,
perfect.
Thank you.
The depressing thing is that I'm the same height as I was in that other clip that we saw earlier.
You haven't changed a bit.
I know.
All right, so in our meeting today, what we'd like to deal with first are some of the key legal issues. And then, Peter, in the second part of our meeting, we'll get into the tax issues. So, Brad, where would you like to start?
Well, I think the first thing we have to talk about is obviously we've started the claim, but my dad is still currently acting as trustee. So we need to talk about what steps we're going to take to remove him.
So that's obviously an important aspect we want to address. We don't want your father to continue to control the trust assets. The issue is whether we bring a motion to remove him and appoint a replacement, yourself, or whether we just go straight for winding up the trust.
Yeah, I agree, and I really don't want to incur the cost of an ETDL, given that we know that there's not that many assets left in the trust, and I want to preserve whatever there is left in there.
Now, we'll come back and talk about this with Peter, because there might be tax implications for winding up the trust earlier rather than later. But just so you know, I'm comfortable that we would be able to remove your father as the trustee. The court is going to do what's in the best interests of the trust and the beneficiaries, you being the sole beneficiary at this point. Now, it can be difficult to remove a trustee, but here, in addition to losing just about all of the trust assets, I think it's key that your father is acting in a conflict of interest. He transferred the house to your sister in breach of trust. He didn't get your consent. He pre-took millions of dollars in compensation. He invested millions of dollars in his own personal company. So there's certainly a lot of conduct that we can attack that I think will convince a judge that he can't stay on as trustee.
I agree with you, and I guess the only question I have is, and we have to talk to Peter about that, is whether we even need to have my father replaced with me, or if we just go right to the busting of the trust. And the other question, I think we talked about this earlier, is whether or not we even attack whether the trust was properly created right from the get-go, whether it meets the test of the three certainties.
Now that's also an option for us. And what's your view on whether we can meet that or attack that test?
Well, I mean, I think that I certainly understood the certainty of intention. I did know that we were creating a trust at the time, even though I was an 18-year-old when the trust was created. And Greg, I asked that you not calculate how I was 11 years old in 1984 and then somehow turned 18 in the year 2000.
I wasn't going to ask.
Because it involves a DeLorean, a flux capacitor, and another child actor named Michael J. Fox, but I don't want to get into that right now. But let's just enjoy my youth. So, in terms of the certainty of the subject matter, you know, I knew my dad was investing in stocks, and so I guess I sort of knew that. But I think the real question is that at the time I didn't have any independent legal advice at all. And is that going to be enough to find that I didn't really make any kind of informed decision to create the trust?
The lack of independent legal advice, the fact that you didn't have a good idea as to what exactly was going to happen with the assets, that certainly gives us the opportunity to attack the creation of the trust and argue that it never should have come into existence. But I think it's probably one of the weaker arguments that you have. I think given that you are now the sole beneficiary, it's an easier course of action to wind up the trust, at least at some point.
Right. So, you know, I guess the other question is, certainly I think we've got a good claim against my father for his negligence, not given that he invested basically all of the shares in tech stocks, and then there's the other issues that he invested in his own business, and on top of that, he transferred a house that he bought from my sister out of the trust into my sister's name. So I think we've got a strong claim on negligence. I assume you agree with that?
I do agree. Now, with the specific stocks that your father invested in, it's an interesting question. You know, before Enron and Nortel tanked, could we say that it was negligent for someone to invest in those stocks? I think what we have to come back to is the fact that your father was acting as a trustee, and that imposed very different obligations on him as far as making investment decisions. So obviously, you know, a trustee is a fiduciary, and that meant that your father had to act prudently, honestly, and in good faith when he was administering the trust assets. So when it comes to investments, that means he also had to act as a prudent investor. So he had to exercise the care, skill, diligence, and judgment that any prudent investor would exercise in making investments. Now, it's also interesting that as a trustee, he had obligations that went beyond just making careful investments. He had to have specific investment criteria. He had to ensure that the investments were diversified. So I think that we can very easily make the argument that your father failed in exercising those duties. That's, I think, going to be an easy argument for us to succeed on.
I agree, and I think we're going to need an expert to give us an opinion about whether or not he acted as a prudent investor as well.
That's right, and when we get a better idea of when and how much money he invested in these individual stocks, we'll be able to retain an expert who can actually give us an opinion on whether those were prudent investments and how he should have invested your money. Now that brings us to the passing of accounts. Now we have some of the information about what your father did and what happened to the assets, but of course we're going to get a lot more than that. Now, do you have any specific questions about the passing of accounts?
I'd like to know how he took $9 million out of the trust without any right of compensation expressly put in the trust, and he certainly never asked me if he could take that amount. And now he's talking about he's actually seeking another $5 million in compensation, which is, I believe, the definition of chutzpah.
So we will be attacking not only the $9 million, but also the further comp that he's looking for. Now, I have to tell you, it's not a foregone conclusion that a specific tariff applies to your father. He wasn't acting as a state trustee. He wasn't acting as an attorney for property. So it might come down to just applying the factors in Toronto General Trust. But we'll be able to attack his management of the trust, the degree of skill that he showed or the lack of skill, and also the conflict of interest that he engaged in investing in his own business. These are all things that we can attack in the passing of the accounts.
Which I guess leads me to my next concern, which is given that he basically lost the entirety of my fortune that I earned on public television that was commercial free. I'm trying to figure out, we have to look for some different pockets to pursue in case there isn't anything left that my dad's left behind for us. So, I think we should talk about pursuing the experts who led us into this scenario where my dad basically took control and has squandered my fortune.
So the experts, as you refer to them, would be the professionals, the lawyer and the accountant, and obviously, as you know, they are covered by insurance. The question really is, what damages are we going to be able to prove that they are responsible for? What was reasonably foreseeable to them as, failing to act competently? And what can we say their failure to do that caused?
Yeah, and I think there's really sort of two potential issues. Arguably, or I think it's pretty clear that I should have received independent legal advice, which I wasn't given. I think the issue is going to be one of causation, though, because even if a court finds that I should have received ILA, in order to show that all of the damages that occurred or the losses that I've suffered, we would have to convince the court that had I received ILA, I would not have proceeded with any form of trust, essentially. And, that I think is going to be, it's an argument, but I think it's an uphill argument that we'd have to present.
It's not a simple case against the trustees in terms of determining what the damages are that they're liable for. But with respect to the lawyer, we have the additional argument that he failed to draft your trust agreement in a competent manner. For example, failing to put any limitations on what investments your father could make, failing to have another trustee who could oversee your father's choices, and also failing to expressly require financial expert advice. Those are all issues that we can point to that we can say were a failure on your lawyer's part, if he was your lawyer, in terms of drafting the agreement.
I agree.
Now, of course, with respect to the accountant, we're happy to have Peter here, who's going to be able to talk to us about what the accountant failed to do and what he might have done improperly. So we're going to wait for the next segment of this meeting before we get into those specific issues.
Have I been paying Peter this whole time?
Part of that $5 million compensation to your father, maybe
Sure.
we could just redirect some of it.
Sounds good.